subscribe to our channel and press the bell icon to never miss a video from LiveLaw.
The observations of the Allahabad High Court in granting Swami Chinmayanand bail has people questioning the manner in which the order was delivered, especially regarding the observations on the merits of the case. Joining us is senior advocate and criminal lawyer Rebecca John. Thank you so much for talking to us, ma'am. As far as the bail is concerned, how do you look at the bail order and consequently the remarks, the conclusions, which show a degree of prejudgment in the order?
So a bail can be passed by a sessions court or a high court in a case like this if there's material to justify the granting of bail. I don't think anyone can quarrel with the order to grant bail, because if the court came to a conclusion that there was sufficient material to grant the gentleman bail, then so be it. What is problematic, however, is the reasoning, and more than the reasoning, the findings, because you've drawn conclusions from prima facie evidence which has not been tested in a court of law, which has not withstood examination and cross-examination, and you've given comprehensive findings. That will definitely affect the case as it goes forward. It will affect the trial, and I don't think courts should pass findings which will have a bearing on the ultimate outcome of the case. So that's deeply problematic, besides, of course, the language used in the judgment, which is, again, deeply problematic.
Ma'am, we were also talking about the balance of power in this case, and especially in terms of giving two sides, whatever the equation be.
So, yes, that's right. I think what was missed by the court was the fact that because this young lady, was in a situation where the accused was able to exercise power over her, and that's precisely the section under which he was charged. Therefore, those factors must be considered at the time of grant of bail. I think I find this whole discourse very problematic, because the minute somebody is a rich and powerful person, the conversations shift around condemning the woman. The minute somebody comes from a weaker section of society, the conversation shifts around condemning the man. And what activists and lawyers have for years pleaded for from courts is to feminize the trial and to humanize sentencing. I think it's important for courts to remember that at the stage of bail, and it doesn't matter whether it's a rape case or a case under the Prevention of Corruption Act, you can only give prima facie findings on materials that are available as of that day, and even that should be done with a great degree of circumspection. The minute you give findings which are authoritative findings on the subject, you have prejudged the trial and you have condemned the complainant without giving the complainant an opportunity of giving her evidence in court, being tested in cross-examination, and following the formal route of a trial. So that is extremely problematic. It is also problematic that despite having taken note of so many facts, it escaped the notice of the Honorable Judge that here was a case where there was such a power differential, both in terms of age and in terms of the power structure that she was placed under. You can certainly come to a conclusion in a given case that a person is worthy of being released on bail, and that conclusion could have been arrived at even in this case. I have no quarrels with that. But the manner in which you come to that conclusion is also something that courts must take particular care with.
Thank you so much for talking to us. That was senior advocate Rebecca John telling us that bail can be granted, but the manner in which bail is granted is something that the courts need to take care of. And in this particular situation, there is a degree of question that comes up when you come with findings before the trial stage in a preliminary bail stage. This is Neelashish Chaudhary for LiveLaw India.